Now, if the petitioner has set out in his or her petition that specific provision that was not complied with, and when it is our case that indeed the second respondent complied with all the requirements of the Parliamentary Election Act and there was non-compliance, there was no any provision cited by the petitioner that the EC did not comply with any of those provisions. My Lord, I will take all those segmented complaints of the petitioner and indicate to you that actually the Electoral Commission complied with the requirements of the law. The first complaint, my Lord, of the petitioner is to be found in section 72. But your petition alleges that the second respondent never complied with section 72 of the Electoral Commission of the Parliamentary Election Act. My Lord, the gist of the petitioner is that the returning officer proceeded to tally the results of the 183 lots first receiving all the envelopes and that's the gist of the petition. And the only chose to read only 72:1. He did not bring this one and report the contents of 2 and 3. And this is what 2 says. The returning officer may open the envelopes and add up the number of votes cast, even though some of the envelopes have not been received. If the candidate's agent and the police are not below the rank of the inspector of police are present. The value does not shift to the second respondent. Prove that actually the agents of the petitioner were not in the 30 center. It is the petitioner to bring cogent evidence to show that the returning officer invoking section 72, her agents were not in the 30 center. That is it. Does it mean that the returning officer cannot tally, even though he has not received all the envelopes? No, the law says that actually he can proceed. 72:2. The only requirement that the returning officer needs to prove before he invokes 2 is to ascertain whether all the agents of both candidates and the taxes then the question valid to you will be, did the EC comply with this section? Is that still a complaint? No. And my Lord, this is not strange. This is not strange. In Amama Babazi, 2016, I will provide you a copy, but I won't read the relevant extract at page Marked at page 141. The court was faced a similar scenario.
Which case
My own, the presidential petition number 1 of 2016. All of us counsel were parties. We are counsel in that matter. But this is what court said at 141. On whether the returning officer actually is close to his power. Proceed to study before receiving all the envelopes. The Supreme Court had to say this. I'll read this, but I will get to the relevant. Furthermore, the petitioner did not adduce evidence to show that the declaration of forms were not filled by the presiding officer after the closing of the polls and accounting of the polls. Neither did he adduce any evidence so that when the presiding officer opened the results, envelopes, before they received all the envelopes from their respective district, there was no police officer at the rank of the inspector police, and above all the candidates, all their agents, bearing in mind the constitutional obligation imposed on the evidence within 48 hours. Now, this is what captured the same scenario that you must go and prove this one I report that if you have a legal grievance under this section, prove two things. You do not have agents in the tax center. That's the number one. Number two, there was no police officer under that rank. Man, you cannot tie for it. The time limits within which you have to declare a winning candidate. So a petition is not at liberty even to abscond or to make his agents abscond from there. If one is missing, at least have a police officer. My lord, there is no such evidence that the petitioner was going to present to the entire center, and therefore this one cannot be a non-compliance. And that brings me to the decision that gave the grievance must interpretation of this act. My lord, this is the act. My lord, we are faced with the question then which other law did the second phase not comply with for it to sustain such a grievance? Then it brings me to a second bit of the complaint. That actually, you're waiting for results. What happens? That there are no results. The procedure in the entire system is like this. And this is the sun. That when it takes place, it closes. The presiding officer fills the DIR forms, and the transmission process proceeds as such. Now, at that point at the tally center, the returning officer is receiving results. Now, this is what the law commands the returning officer to do. One, if you have an envelope and it does not have results, that is section 72.3. And I'm not invited to party. And this is a scenario that really happened. You are a returning officer, you are waiting for results. The envelopes are coming. If you go to the envelope and you can't find results, it directs you to go to the report book. The law commands the returning officer look at the presiding officer's report book. Now, if you can't find it in the report book, The law commands you to go to the ballot box itself. My lord, there's a presumption that actually in those two, you will find the results. The second thing the law commanded you to do is to reseal. The only requirement you need is again to have the other police officer at that rank. But it's the scenario. Now at that point, if you can't find those as a returning officer, right from section 72, is that the only option left to you as a returning officer is to declare. My lord, the law does not tell the returning officer to run away. And this takes you to what the petitioner's counsel was proposing, that actually what you are declaring are provisional results. No! These are not provisional results. I'm yet to be convinced by the petitioner in the brief set in my grandma's case, Ode's case, and Jim that the returning officer never complied with this section. The only option left is to declare as a returning officer. Another section, my lord, is what you wrote and noted yesterday in the case of Dating and those exceptions. And I invite you to read this case. Those exceptions that they gave: 2, if lawyers can't be found; 3, if they are missing. And by the way, this section does not even impose a duty on the returning officer to inquire. No. It only commands him that now that you have suspected that you have all this, there are possible ways of where you can find the results. The vote book, the ballot box. After that, proceed to declare. And if you do that, you have not, that is not non-compliance. And my lord, we have been guided by the Supreme Court on such a command of the legislation in sit and several. My lord, this is the election petition appeal number 6 of 2009. It is not up to the suitors, the petitioner, to propose a sanction within the law or to amend it within the law. My lord, while the Supreme Court was dealing with Section 50 of the Parliamentary Elections Act, then it was on the other forms. My lord, in that case, that some users were declared on the woman, the dear forms of a woman, district woman member of Parliament. And the argument was that this was not a prescribed form. And what has this to say? That we observe the second phase of the Parliamentary Act, which describes the procedure in regard to education of these forms, does not prescribe what will be the effect or consequence of its non-compliance. It appears to me, and that is called, that the section is directed in the sense that it directs how election results and paperwork collected here which should be done. Mere non-compliance with the state in the procedure will not affect the results. And the appeal was dismissed. And in my lord, when you retire to write the judgment, you retire and address yourself to that decision. When you read section 72, it gives you the procedure. Like available to here, it gives the procedure. That even if you are to agree with them, that actually there was not compliant with that procedure. So long as the intention of the returning officer or an administrative body like electoral commission is achieved, it is not for the petitioner to say that has affected the results. And this is simply what my role. And it's also addition that my role, that in a given scenario, the petitioner cannot purport to say that EC did not comply with the provisions of tariff and declaration. And actually, and indeed that was not provision there. And the question would be, then what would be the final result? And where do you read the provision results? My read the results of an election is to be in the return form. Under section 77 of the Private Elections Act. Whether that return form was properly filled is annexed to the petitioner's petition. So the process was complete. The tally sheet and the data forms of 183 polling stations, which translated into 92.7% of the registered voters of Kawai. That result represents 92.7% of total registered voters of Kawai. That now you are first to take a decision between 6%, representation of 6% or 7 vis-a-vis 92. The petitioner also has 20 proposals and invoke the non-applicable section. But if I take into that matter, then in the circumstances, what is the returning officer after declaration as responsible as administrator of elections? What did he do? When you read the affidavit of the returning officer, I think it's paragraph paragraph 11. That the following day, the returning officer reported to police. Under CRB 350/20, CRB 350 merit /2025, and CRB 356/2025. Probably that's what an administrator or the returning officer will do for them to investigate.
What was the report about?
The report was about the violence that was reported to him on the 14 polling stations. And I'll take it there to evaluate. Because like I just admitted, the electoral process is a progressive nature. You're already there. The law does not say go down. You're in the transmission process. You must first complete the tallying process. One would presuppose, maybe like the petitioner wanted, that please hold on to the envelopes you have, rush police, investigate. No. The flowing river principle applies. Finish the process, have the winner declared, then report the relevant authorities. And this is what the electoral officer did. My lord, that fact by the petitioner has not been responded to in the rejoinder, has not been denied, secretly put, and as we speak, maybe the investigation is still ongoing. And that's what we can do as an electoral body, that we give the relevant authorities to investigate. That for you to suppose that you stay the entire process, you wait for the envelope under section 72, my lord, that is not tenable, and that is not a command of section 72 in the tallying process. My lord, we take it to the fourth complaint of the petitioner. Interruption. You coached the petitioner coached her complaint on section 76. Interruption, postponement, and counting tariff process. Madam, you're faced with a very peculiar situation. What this section presupposes is that actually when the violence erupts, you are given the time to prepare and safeguard the rest of materials. That's what it presupposes. That you hear noise, people are carrying stones, the mob is being organized, then the electoral body very fast secure the electoral materials for you to be able to postpone the counting. And mind, this is what comes out in the other evidence, supporting evidence. What is not in quotation is that the polling process was peaceful in the 14 polling stations. That measures had been taken by the second respondent to put all electoral materials in the press. Voters stand up in huge numbers to cast their vote. Polling closed at 4, with no major incident reported by the petitioner. Only other person in the electoral process. But from the evidence of the supervised or designated officers is that at the point of sorting, all those who have participated in the process, is that in this process of sorting, now the Farida is here. NALUKOOLA, it is here. Serogot is there. After that process of sorting, there is a heap here, there is a heap here. Now, the winner will be suspected. The loser is suspected. And I don't want to be misquoted for me saying that maybe this could have been attributed to any of the parties. That is when the mob came in and smashed, destroyed the key electoral materials. And these are the key electoral materials. And that's taking back section 72, because if I not evaluate section 76 in this total disregard of section 72, what were the key electoral materials? One, the report book. Where the returning officers were elected under 72. Two, the ballot box. Three, the DRR forms. My lord, that is the process that the 14 points that was interfered with.
All of those documents were destroyed.
Destroyed. It's an act of God, maybe. But that's an act of Satan, because. But none of that man is responsible for this. And man benefited. But not to be different if the winning candidate gained a fair advantage. And how do you tell that you have gained a fair advantage? If at that point maybe the rest of other politicians had been done, that may be number one. You say they this one gain because he was losing, they be organized. And then of course suggestion for the other parties, none gain. My own person, the petitioner cannot come this court to take advantage of this act of Satan. To take us back to the polls. I remember this is where I want to read that this court now he has been under Article Section 82, 5, Rule 4. That persons who are duty to inquire what has intended the inquiry could be the evidence, and indeed it is this evidence, that before you take your decision, make a thorough inquiry. That are you going to give us a decision or a precedent that politicians or supporters of politicians, my lord, or politicians, my lord, or supporters of politicians will always organize themselves in a mob to interfere with the process to access this court? It is a precedent that we are going to look for. Moreover, in a situation where none of the parties benefited, my lord, we have got it from supporters that actually all politicians, be it winning, be it losing, are desperate to win. And that's why court, in one of the authorities, submitted that even when there is evaluating the evidence, is that you have to give it the care, attention on that. But it calls for wisdom from the presiding judge that you do not want to have a judgment that is going to set a precedent that supporters can interfere with the work of the electoral body, to fail it to declare, or to use it as a vehicle for a by-election. And why by-election I say it calls for wisdom? Much as I'm a lawyer, I've been forced, my lord, to get one of the interesting verses of the Bible. In making a decision, that is 1 Kings chapter 3, verse 3:15. And my lord, this is about the story of King Solomon. We are all familiar about that story. When he was confronted with a child, and the child is Kawempe, and he said, now what do you want? The other person said, kill. I'm not filling the petition, I don't want to discuss it. The judge said, no. My lord, you need that wisdom. Because this debt only calls for wisdom. But my lord also bothers you that at cross-examination of the petitioner, she says, I couldn't get 100 in the 14 polling stations. Yes, I could win in some, but I could not get 100. And that's why I was, then what? You don't want to be care? You don't want anybody to be care? Where is our child? So, under the inquiry, my lord, that is an area that you invoke the first king, or Solomon, for your decision. Then, my lord, after taking all those alleged non-compliances, and having convinced you that actually none of the provision was not complied with, and indeed, there is no section of the law that has been pointed, there is no evidence to that effect. This way there is non-compliance. As for petitioner, at least not the petitioner, proposed. That's why they didn't postpone and count. I've already submitted this one court. That was impossible. Even if this court directed today to conduct election, I don't know what it will be, in the 14th. It is not possible, my lord, and the principle of adult suffering. If it was the following day, it is not possible for the electoral body to have even to propose to have elections in the. Why, my lord? Is at the timing of the mob had frustrated or had an effect on the entire constituency. Why, my lord? And this is what I'm submitting. One, that the results of other polling stations have already been announced, and that has an effect of the proposed election, the 14th. So the body itself, the second body will not. And simple reasoning, none wants, at times that the majority want to associate themselves with the losing candidate. So the results in other polling stations would have an effect on the 14 polling stations. So that is not even possible. So one, you can't order for or postpone elections or repeat elections because the already declared results from these other polling stations will have the effect on the 14th. And it's simple principle. Because under this election, that even one voter can make a difference. And that is not available. So, counsel for the petition and this proposal for that. What were the rush? No. That even if it is today, you can't have that election without it. I ordinarily, after convincing you that was no non-compliance, I would probably have stopped that. But if you're inclined, my lord, 5N is onward. The framers of the law never anticipated that you are going to have an excellent election. And that's why they say the family seems to be free and fair. Not excellent and exceptional. No, these are gradings. That is number one. Number two, that actually it is not enough to annul. It is not enough to annul. That non-compliance must be substantial. So you have a huge burden as a petitioner. That will test my role. And it appears to the petition is only on the numbers, on the letter test. On the quantitative. And this is why our point of departure is. I really associate myself with the principles of the law. In as far those authorities are supplied to my law. But only the part where my lord, and I must approve Mr. Kabule, that when he gave some judgments, he picked those that favored him. The portion of the judgment. But you need to. I refer to one of the judgments, my lord, a change Sarah Penny. The Court of Appeal, it was supplied by him. And my lord, I'll refer you to page 21. I'll give you my copy as well. What did we consider? My lord, counsel for the petitioner omitted the good way it is to bring this fact or principle to you. This is the authority that trial judge have compared the aggregate number of registered voters from the 17 polling stations of 8,144 together with the reading by the first appearance, and then conclude by washing away the first appearance in my winning majority. Now this is what he wants you to do. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Electoral Commission to exclude the votes from the 17 polling stations from the final tally of the results. My lord, there is one thing. In fact, here, the Electoral Commission has admitted. Here we didn't even admit that there was none to admit. And this brings with all the decisions that were supplied by counsel for the petition. And the only distinguishing factor, my lord, is that in all those decisions, there were results. And at this point, I should distinguish them. There are results. That's number one. Number two, is that in all those decisions, my lord, the rules have been tampered with in terms of altering them, in terms of returning officer deliberately not including them in the tariff to favor the other candidate. But more interesting is that in those, the margin was very slim. I invite your lordship to look at them as well and be able to reduce the fact that indeed they are not applicable. My lord, the court, after faulting the trial judge, they went on to say the respondent therefore had to decide the verdict that she should have got the majority vote if the votes from the 15 polling station are reflected to the account. She had the requisite evidence to prove or disapprove this. She did not abuse it, and thus she failed to discharge this burden. So, my lord, all along, what counts for the petitioner was to invite you to consider the 16,640 registered voters vis-a-vis the difference, which is 8,000 plus. My lord, this judgment, which is applied by himself, says no. That is not the formula. That you cannot give here and wash away. Because you owe the petitioner, the respondent, you suffered equally. My lord, this is submission of course. There's a couple of but it has highlighted the very part he wanted and omitted the part we want you to rely on, my lord. This court counsel of the petition is applied to the judgment or objection number 6 of 2021. Electoral Commission appearance versus Mosuku Jacob. I also want to distinguish. I want to distinguish this judgment. One, that it is not applicable in the trial of parliamentary elections. This was the local government case. And if my lord, I'm saying it is not applicable, and I'm supplying you with this authority that it's confined such a decisions from being relied on by this one I court trying and implemented to that. And it's very simple, my lord. This decision is yes. My lord, the dilemma discussed in the case of Maputo Augustus, this election petition number 73 of 2016, versus Western David and the Electoral Commission. It is not a my lord, one, it's court of appeal, my lord. One, and this is where I will apply the glass, because of the different standard under section 80. My lord, the standard under Parliamentary Election Act and the local government is different. And not everybody, I'm going to read you the extra, the decision of court. Most especially the one of criminal. But in that, my lord, is that court had wanted to purport to invoke, I know the equivalent section now, by then it was 172, to apply the provision of Parliamentary Elections Act to apply local government. Court said no. The standard is a balance of priorities. It does not exist in local government, my lord. What we are required to prove is the satisfaction of court. In the decision that was submitted to you, the standard was different. Satisfaction of court. My lord, here, as well as submitted by counsel, and he took the different decisions on the balance of probabilities, it is not available in the trial of a local government petition. I submit. My lord, even if you have to follow principles, like you know what they want you to do, it will still be distinguishable. In the sense that, my lord, there were results. In Mosoko, there were results. My lord, here, there are no results. And it is explaining. In that one, the margin was very minimal. And to be very exact, my lord, was less than 100. So, my lord, that and the principles are not applicable. My lord, you also surprised with the authority of budget. It's also a submission. You cannot apply. Is it in budget? Like I said, there are also results. But interesting in budget, in a tampon station returned 100%, and was doubtful. So when as you evaluate it, you find out that in budget, there was evidence adduced that up to some people had traveled, some were dead, some came up to say I never participated. They should have. Therefore, would you get 100% of the polling station? The scenarios are different. But you're faced with a new scenario. Which cannot be resolved by the principles in those cases. I read council was given that, my lord, we certainly that the second respondent did organize the free and fair election. The declaration of the count of the first respondent was based on the majority vote, and that is to say 92%. That would be unfair for the 7% to influence and to be put my road at the 16,400, 640. And influence 180. The list of voters. That my road has quite submitted that failed to discharge his duty. Going to this one, I report which act of the parliamentary was not complying with. And those cited that he glossed over, there's no evidence supporting them. Have the right report. And finally, you'll be pleased to dismiss this petition. My Lord is posted regarding and that's a fact that actually his interest is not in this petition itself. That my Lord will be our cost. Mr. Blake, my Lord. Thank you.
My Lord, good morning. I'm a Lord for the record, Alex Muganda. My Lord, for the first respondent, our submissions in reply will be structured and we shall flow the same way we did for the proceeding. We'll have 5 of us handling the different issues that we handled. However, for the preliminaries, I will briefly make a response to the preliminary objections that were raised by counsel for the petitioner, after which I will take leave and senior counsel Babazi will come on later. My Lord, there were basically 3 appeals that were raised. The first one, counsel for the petitioner is asking courts to strike out number of affidavits sworn in support of the answer to the petition on the ground that they are predated.
My Lord, I would like to briefly submit that the criminal objection itself is misconceived and not grounded in law. The criminal objection itself is misconceived and not grounded in law. Because Rule 8.1 of the Parliamentary Elections Interim Provisions rules that counsel cited in support of the criminal objection does not talk about predating, nor does it talk about when, the various affidavits the various affidavits in support of an answer to the petition should be dated or drafted. My Lord, Rule 8.1, referred to above, is to the effect that upon being served with the petition, the respondent should within 10 days file his answer to the petition with the accompanying affidavits.
And my Lord, what the petitioner's counsel is doing is the father of the house leaving the dining
Table and going into the kitchen, and is complaining that you have put the salt before the onions. My Lord, within the 10 days
that the respondent has under Rule 8.1 is expected to gather his evidence in those 10 days. So if you have a number of allegations against several people, whatever day you get them in the 10 days is fine. What the law requires that when you're filing, all these must accompany. Now there is no evidence on record, my Lord, that any of the affidavits that is complaining about was filed in court before the respondent's answer. What we have on record, my Lord, is that the answer, together with all the evidence and affidavits, were filed on the 24th. Were filed on the 24th. So, my Lord, before the 24th, when the filing of the respondent's answer was done, there was no answer. Neither court nor the petitioner would be able to tell whether there is an answer. We can only talk about an answer under Rule 8.1 when it is filed. And my Lord, there is no evidence on record or adduced by the petitioner to show that there were any difference in filing dates of this answer. And it cannot become an answer when it is still in the lawyer's chambers. So what counsel is looking at is the kitchen affairs. He peeped into the kitchen. But what we are saying is that under Rule 8.1, you wait for the food at the dining table. And it came to the dining table on the 24th. And my Lord, precisely, there is no issue as far as those affidavits are concerned. And we beg that the court be pleased to overrule the objection. But my Lord, in the alternative, even if we are to say that there was a problem in putting salt before tomatoes or mixing them up, my Lord, one of the authorities that was supplied by the petitioner's counsel under volume 3, my Lord, in the bundle, that is Muhindo. Rema versus Winfred Kiza, my Lord, on page 886. On page 886. My Lord, that's volume 3. My Lord, that case citing the Supreme Court's decision of Colonel Kizabeskie and Yoel 7, that is number 1 of 2001, on page 886 of the bundle. The Supreme Court held that the court should take a liberal view of affidavit petitions considering the tight time schedule under which they have to be compiled, unless the omission is material and going to the root of the substance of the affidavit. My Lord, when a respondent is served with a voluminous petition of over 1,000 pages, with a periphery of allegations against everybody in every corner of the constituency, it is not possible, as counsel would want it to appear, that you collect all these people, they leave all the work they are supposed to do, so on the final day when for you are doing your affidavit is when you should now start getting their evidence. No. And what we have been doing in election petitions, the moment you are served, you get a number of lawyers, and each lawyer handles different people. Respond, respond, respond. What is important is that when you're filing, you must file on the same day. So it's not that whoever prepares evidence, they file it, not. And when they are all going, they go in support of the petition. And that's what Muhindo and the Supreme Court is saying, that we should not be very strict on those issues. My Lord, on the other objection, which was addressing the issue of annexures, on the issue of annexure, my Lord Counsel took at length to impeach this particular annexure, and we, on observation of the same, note that this annexure was intending to support evidence on the total number of registered voters in the 14 polling stations vis-a-vis the total number of registered voters in the constituency. And this is a document, as alluded to by the first respondent, had been obtained from the Electoral Commission. However, with the hindsight that the same evidence has been adduced by the petitioner in the tally sheet and in the attached voters' rolls for the 14 polling stations, my Lord, we will concede to this on that annexure. My Lord, is one, which is the parking list, but its complex, it has not been marked. Annexure A to the affidavit of the first respondent in answer, in support of the answer to the petition. So we can concede to that because that evidence is already on record. But it can be done away with as prayed. My Lord, the third and last appeal that was raised was in respect to the affidavit of NALUKOOLA Rita. My Lord, it was the submission of counsel for the petitioner that NALUKOOLA Rita's affidavit did not comply with the requirements under the Commissioner for Oath Act. But our submission briefly in response, my Lord, that counsel for the petitioner's submission is unsustainable because he does not lay a sufficient background. He doesn't lay a sufficient background upon which such a prayer can be made. My Lord, when you look at the affidavit of NALUKOOLA, it fully complies with the requirements of the Oath Act. It was duly commissioned by an authorized officer. My Lord, under cross-examination, the witness before court told the court that she appeared before the commissioner for oath. She also told the court that they explained to her the contents of the affidavit. She also told the court that after explaining, she got her copy and read it. She also gave evidence that she swore. And the only question which the counsel for the petitioner put before her is whether there was a book. In cross-examination, whether there was a book, was there a book? And it remained vague as that. My Lord, when you go to section 5 of the Oath Act, the requirement, the main requirement, and this has been demonstrated in a number of authorities, is that the deponent must physically appear before the commissioner. And the deponent must understand the nature of oath she's taking and what she's swearing onto. My Lord, all the cases, including John Baptist Kapoza, that were supplied to this honorable court by counsel for the petitioner. In all